Welcome to Family Forum. I'm the NAMI Finger Lakes Executive Director, Beth McGee. Thank you for joining us for tonight's program. We're going to learn about opportunities for future planning, including special needs trusts, ABLE accounts, and other options available to us. NAMI Finger Lakes is your local affiliate of the National Alliance on Mental Illness, the nation's largest grassroots mental health organization dedicated to building better lives for the millions of Americans affected by mental illness. Locally, NAMI provides a hotline, support groups, and education and advocacy opportunities for families and friends of people living with mental health conditions. All of our services are free. This event is being recorded and will be available on the NAMI Finger Lakes YouTube channel soon, where you can also find our previous family forums and other events. After tonight's presentation, we'll have an opportunity for questions, which you can submit in the chat. Please hold your questions until that time if you can, so we don't lose track of any of them. I would like to welcome David Young. David has served as the Intake Director at Disability Rights New York since 2014 and supervises a team of attorneys and non-attorneys in providing brief assistance, information, and referral to individuals throughout New York State. Prior to joining DRNY, David worked in the trust field, first as a private attorney, then as a trust officer for a large nationwide bank, and finally as an intake director and trust administrator for a large pooled supplemental needs trust company. Tonight, David will share a presentation with us and answer our questions. Sounds like he is fully qualified to answer these questions. 1 second, please. Admit everybody. So welcome, David. It's great to have you joining us. We get so many inquiries about these questions from families and how they can protect and provide for their loved ones. So we hope that we can clarify a lot of these options for people tonight. So would you like to introduce yourself?
I will do what I can to answer the questions. I'm going to be totally honest here. I may not be able to satisfy everyone's curiosity. Some of this stuff is going to be very personal and individual, right? It's going to be about you or not you, but it's going to be about a very isolated fact pattern that I may not be able to answer in full over a presentation, but I'm certainly going to give it my best shot.
Great, thank you. And so if you would want to start with a brief introduction of yourself and the organization you work for, and then you can get started with your presentation, that'd be great.
Absolutely. As we read out earlier, I am David Young. I'm from the Disability Rights New York agency. I'm the trust. I've already screwed up my resume, and it's mine to screw up. How is this for a start? I am the Intake Director for Disability Rights New York, and that is my most recent position. I've been here for 7 years, maybe a little older than that. And it is a wonderful opportunity where my team and we get to help individuals all across the state with questions, brief service, limited scope advocacy is the buzzword that we like to use. And in general, we assess the issues that come in for possible systemic remedies, for assistance on a larger scale, and through our various programs that we administer. Prior to that, I worked at NYSARC in their trust services department. It was an eye-opening experience and a look at the inside of a pooled trust that it certainly shaped a lot of my outlooks on certain practices and procedures. But it was great to get to help so many individuals, hundreds of individuals every month were coming into our agency, and what they wanted is something that I think many of us can relate to. They wanted independence, they wanted to maintain their life in the community, and they were often afraid of being institutionalized due to a lack of home care, due to a lack of resources, and due to a lack of supports. So it was a great experience. Before that, I worked for KeyBank as a trust officer. So it wasn't as glamorous or as nice as working for a nice nonprofit where you get to feel a little bit more hopeful in the day. It was a bank after all. Hopefully no one from KeyBank will ever hear this and come after me for besmirching their good name. But I made a connection with so many individuals that I was able to help. We had a number of supplemental needs trusts, and I was the administrator for most of the ones that our department had. And prior to that, I was the guy who would help people set up their trust and who'd give that individualized advice when people would come into my door or come into my office and say, here's what I want. I want to make sure that my son, nephew, niece, cousin, whoever is taken care of. And I want to know what's the best way to do so. That was kind of my start. It was where I always thought I would end up, actually, practicing the law, helping individuals with their estate planning. But life takes other journeys, and I'm helping so many more people on any given day now than I would have been in private practice. So I think it's all worthwhile.
Thank you.
All right, I guess I will start with the presentation now. All right, share screen. And hopefully this is going to work. All right, here we go.
There it is.
All right, it's beautiful. So this is the slide that explains our organization, Disability Rights New York. We are the state's protection and advocacy system and the client assistance program. I know we have, as an agency, a much longer spiel to give on who we are, what we do, how we got here. But the long story short is that there is a protection and advocacy system in every state, and we were designated as New York's. What the agencies do differs from state to state. Our goal overall is to try to assist individuals with disabilities, maintain their autonomy, exercise their rights, and be free from abuse and neglect. I think that's a very lofty goal, but it's the one we try to maintain. What is a trust? This is a deceptively simple question because it's so basic. A trust is literally giving anyone anything to hold for a reason. And the complexity comes from that flexibility, in that depending on the trust, the donor could be the person who is also the beneficiary of the trust. They are giving it to themselves with one name as opposed to another to enjoy some kind of a benefit or to subject themselves to some kind of a rule, and often for reasons that are usually, hopefully, pretty altruistic. The main rule, as I say there, is you can't violate public policy. You can't give yourself, as the trustee and the donor and the beneficiary of a trust, all of your money to hold in trust so long as it never goes to that creditor that you don't like. That would not be consistent with public policy. That's going to fail. But trusts are a wonderful instrument in terms of how we set out what we want to do with our assets. The trust that we're mostly dealing with today, it's going to be just without having done an official survey, I'm going to assume we're mostly interested in testamentary trusts. So we're thinking about how do we create a trust in our will that will enable us to pass along assets subject to certain restrictions to benefit loved ones, family, friends. The relationship can be all kinds of things. There's also a possibility that some of us are here for a living trust. We have someone that we're caring for right now, and we're interested in preserving assets while we're still alive. And we just want to get ahead of the jump because, unfortunately, after we're dead, it's too late to fix some of the mistakes. And so we really want to get to the nuts and bolts of what we would like to have happen with our assets before then. What I can tell you is this is not going to be a sales pitch. This isn't where I will come in at the end and say, like, for $15.95, you can buy my trust creation kit, and you too will have a functioning supplemental needs trust. I'm really going to direct you back to an attorney, a private attorney, most likely, who can help with individualized representation. This is just things to think about when you're having that conversation with that attorney. Now, some basic definitions. I will say I promise myself, and I don't know that I'm going to keep this promise, but I promise myself I would try to be as user-friendly as possible. If I use too many big words, hopefully someone will give me a poke and say, knock it off, no one understands what you're saying. So I thought it would be helpful at the outset just to lay out some of the definitions here. A donor, a grantor, that's the person who puts the thing into the trust, whatever it is. For the most part here, we're going to be talking about money. I think that's what many of us are preoccupied with, but a trust, because it's so flexible, A trust could include a house. It could include your intellectual property rights to that book that you've always wanted to write but have not yet got published. It could be a fractional interest in a closely held corporation that is divided up among 16 other relatives. The body of the trust can be almost anything. The trustee is the person that is going to be holding on to the funds. They're the person that is most likely to be the person to violate the rules that we're going to talk about later. They're tasked with a heavy job. They have to see what the needs of the beneficiary are. They have to see what the intention of the donor or the grantor was and try to reconcile the two. It's not an easy balance. And depending on who the parties are, you may be more inclined to give a trustee more leeway than another trustee. A trustee could be a family member, a friend, someone who has a vested interest in the well-being of the beneficiary. And so you might be a little bit more forgiving if they forget some of the rules regarding the taxable consequences of the distribution of income upon the principal, blah, blah, blah. When it's a corporation, you tend to be a little bit more in favor of holding them strictly to the rules, and you should know what you are doing. But we'll talk more about what those rules are later on. The beneficiary is by far the most important person in a trust because without the beneficiary, there's no reason to have a trust. Every time I want to write this out, I keep wanting to avoid the word benefit because you shouldn't define a word with the word, but it's really hard to when you have such a flexible term as the beneficiary and as a trust in general. So the beneficiary is the person who derives any kind of benefit whatsoever from the trust. Now, for our purposes, with an SNT, for instance, we're going to be talking about the person who the trustee is distributing income or principal to for the purchase of clothing, vacations, TV, electronics, the cable bill, those kinds of things. But there are also remainder beneficiaries, those who stand to take whatever is left over in the trust at the end of the day, when the trust is all said and done, usually upon the death of the beneficiary. Now, with certain trusts, the trust itself may have a disposition. They may have a way of handling what happens at the end of the beneficiary's lifestyle at the end of the beneficiary's life that depending on how the trust was funded, it will either be a distribution to the local Medicaid office or it'll be a distribution to third parties called remaindermen. We're not going to get that far into that rabbit hole of how and where, who gets what funds, and at what point it'll go back to your estate. That's really a conversation for another day. But as long as we have that as a general framework, the donor or grantor puts the money in, the trustee holds the money, the beneficiary is the recipient of the benefit. I think we'll be okay. Now, more definitions. The corpus, it is what is held in the trust. We're going to get into some fancy distribution rules here if we start talking about principal and income too far, but the high level version of this, a trust can have anything in it. Mostly, again, we're talking about money, but it could have a rental property. So that rental property could be throwing off some income. There are distribution rules as to what you can do with the principal. There's distribution rules as to what you can do with the income. There's distribution rules about what you get to do in terms of trustees' fees for how you spent either one of those. It's really a mess sometimes. So we're going to really look at it from a very simple point of view here. Everything that is in the trust, we're just going to call the trust assets, at least for this conversation. If there is a question about something specific, we might have to table that for later. But overall, if it's held in the trust, we're just going to call it assets as a general term and move on from there. Now, a supplemental needs trust or a special needs trust, it's one specific type of trust. It has a number of rules. First and foremost is that it is for the sole and exclusive benefit of the beneficiary. The purpose of these trusts is to preserve a certain level of assets for the beneficiary's life, subject to certain terms and conditions. It cannot be spent on anything that will, it is meant to supplement but not supplant a person's benefits. And what that means is that if a person, the beneficiary, is receiving SSI or Medicaid, the assets in the trust should not be distributed in any way that will jeopardize those benefits. And typically, that is housing and food. These are the two distributions that are most needed by individuals, and yet they are absolutely going to cause trouble if made from a supplemental needs trust. Because what will happen is your local Medicaid office, your local Social Security office could look at that distribution and say, if you have a trust that is able to pay for your housing, why am I giving you $812 a month now for SSI? You should be using that trust money first. So it's a little bit cruel, in my opinion. This isn't a legal term. This is a me term. It's cruel to have that in there, but it's part of the bargain in preserving those assets. You can't use it for the things that are most fundamental for life because there is another benefit out there that should be taking care of that. These rules are very complicated. I have some questions here. Who can be the beneficiary? Who can be the trustee? What can the trust assets be used for? What I can say is that it really depends a lot on the type of assets you're putting into the trust. That will determine who can be, or what the trust assets can be used for. If, I will talk about this in a few slides from now, but if the beneficiary is funding the trust with money they are entitled to, it's a first party trust. And there are certain rules that come into play there, such as when the person dies, their money will first, or any money left in the trust, will first go to pay back Medicaid or any medical services that were provided throughout the person's lifetime. If it's a third party trust, which is a trust where I, as a loving and benevolent person who happens to have a set amount of assets that I would like to make sure go to be used for someone else, that is a third party trust. And what I can do with that is I can set certain other rules. I can say when I am done with that, or when my beneficiary is done with that, they will then, that money will then be transferred over to another organization, to another person, to another purpose. Maybe it even goes back to my estate if I hadn't prepared that thoroughly. But those are some of the considerations to be made later on. Now, I think that's all we have on that slide. So let's go to the next one. There we have a few bullet points on what makes a first party SNT versus a third party SNT. First party, it's funded by the beneficiary or from money the beneficiary has a right to. The distinction I'm trying to make here is that it could be savings. You could be going along having an ordinary, average, everyday life, and then at some point, a disability has onset or has become onset, whatever the exact phrasing should be here. And for whatever reason, you need to preserve some assets to be eligible for a trust. That is when a first party SNT might be useful. The more typical example of this is that personal injury award that I've got listed down below here. There was no disability until that car accident that injured you. Now there is a disability and there's a pot of money that will be coming to the beneficiary because of that injury. I say here that the beneficiary cannot revoke the trust. I'll explain a little bit later, but there's a good reason for that. And that is the more power a beneficiary has over the assets, the closer it is to actual outright ownership. And the government doesn't like the idea of someone being able to turn on and off rules as it benefits them. They are really reluctant to encourage a system where you can say, this money is untouchable if I have to pay for housing. It's untouchable if I have to pay for Medicaid, but it's totally touchable if I would like something that I want, and I see fit to use it this way. So on the deathbed, I have here the remainder gets distributed first to Medicaid, then to whoever else may be in the person's estate. As I'm sure is no surprise to anyone here, a lifetime of medical costs is sometimes quite costly. It would take a significant amount of money in the trust to pay for most individuals' Medicaid provided services over the cost of their lifetime. So it's generally just a wash. Whatever is left in that trust is going to go to Medicaid. It is likely not even enough to pay for a fraction of what Medicaid outlaid in terms of medical services, but somewhere someone is actually keeping a tally of every single dollar that Medicaid has ever spent on you. And when you pass away, Medicaid is going to go to the trustee and say, here is a list of everything we have ever spent. We want as much as we can get from this trust. And as the kids say, they have no chill. They do not wait. They do not care that you are in mourning. They will start the process almost immediately, and they will make sure you know they are the first person to get paid before anything else. When it's a third party, that's the testamentary provision here. That's what we're talking about, where someone puts it into a will that says, I have passed away, and here's what I would have liked to have done with this money. I want it to go to this person for their benefit, and I am not there to make that happen. So the beneficiary cannot revoke the trust, but here the key word is beneficiary. Depending on the structure of the third party, there may be someone else who can revoke that trust, just not the beneficiary. It's not subject to Medicaid repayment. And in fact, if you are making a third party trust and your attorney suggests that it needs a Medicaid repayment, there's an argument for malpractice there. It's a conversation to have. Why would I want my money to go to Medicaid when I have other stuff I would like to do with my money? I put down here the example of inheritances. It's important to note that the inheritance, the third party trust has to be done through the will if it's going to be an inheritance. If we're talking about a will where all of the money goes outright to my beloved son, daughter, whoever, and they get that money and they want to turn that into a trust, we're talking about first party assets at that time because the money has already entered their hands. It was money they had a right to. It's money that it's kind of escaped any possibility of a third party. Can you go to court? Can you say the intent of this will was to create a supplemental needs trust? Sure, you can try it. You might want to have some evidence, hopefully written evidence, that this was truly the intent of the parties when making this trust. But it's going to be a hard sell, really. It's likely going to be seen as a distribution from the will, from the estate, directly to the beneficiary. And that beneficiary is now looking at creating a first party trust. But again, that's an individual circumstance. The whys and wherefores as to when it will be considered totally in their hands, that's a very fact specific question. Now, we're going to return to that concept of the public policy here, and I talk a little bit about the first party and the third party reasoning why. I already mentioned the government does not want a system where you can turn on and off the rules. It's hard to respond to the need of the individuals they're trying to serve, and also their own budgetary concerns. If you can just turn on and off Medicaid eligibility with a switch on a paper, it's going to be too much for them to manage. So it's an all or nothing deal. And as far as the third party, there is a public policy consideration here that the government likes it when people care for other people, usually because it means they don't have to care for those people. I don't mean it to sound cruel and callous and heartless, but if you can help take care of a person, the government's really happy to have that happen. And so they know that any kind of a rule that says you will, whatever money you set aside, you will give first to Medicaid and then you can do what you want. they know that's just going to discourage people from setting up a supplemental needs trust for their beneficiary. Nobody wants to give their money to the government voluntarily. That's why we have to have tax enforcement. Now, a pooled SNT, this is, it's a type of trust. Typically, it's a first-party trust. It's a beneficiary putting their own assets into the trust. They're called a pooled SNT because the money is pooled. A lot of little people, a lot of little donations. There's no little people in the trust world. There's only little trusts. But a lot of people with small amounts of money pool that money into one large pot where it can be more effectively and efficiently managed. What this means is that if you as an individual investor had to work the stock market, it may be a lot of work for you as an individual investor. Trying to keep up with when to dump those Apple stocks, when to start considering Bitcoin investments, and whether or not you should go all in on GameStop stock. That's a lot to put on any individual. But if you combine many small trusts into a big $90 million behemoth, then you can have one person making decisions about where to put their money. And it is also more efficient for the little things in life, like writing an individual check. When I was at a big bank, we wrote our checks individually for individuals. And by writing our checks, it meant a lot of tedious data entry into a system that would then process a check and send it out to Milwaukee, who would then print it off and stuff it into an envelope, who would 9 days later mail it to somewhere else. It was a tremendous burden. And it took as long as it did at the pooled trust company to simply data enter several checks into a spreadsheet that was then batch uploaded and printed off one right after another overnight at a bank. It's just so much more efficient when you have a lot of little transactions. Those day-to-day transactions like light bills, credit card payments, things that are almost mechanical. There's an efficiency that can only be achieved at scale. Now, I have here that pooled SNTs are maybe the only professional option for trusts that are too small to interest banks or other professionals. That number, the dollar amount for which a trust is too small, I didn't include it here because it depends a lot on the trust or the bank and the trust company. I can say that years ago, $100,000 was too small. And that was for a nice sized bank, but we really actively discouraged people when we got down to $100,000 in an account. All of a sudden, it became more about, can we spend this money down reasonably and responsibly so that we don't have to deal with the recurring statements, the pressing thought of being litigated against or sued by our beneficiary for whatever actions that we might have taken. It became more of a liability than we were willing to take on for the amount of the trust fees. And the trust fees, depending on the nature of the trust, can be quite substantial. They can also be quite minimal. And we're talking about 1% of a trust. So on a $100,000 trust, we're talking about $1,000 a year a bank would get. That $1,000 would go into 12 monthly statements, which not a whole lot of money, but conversations with beneficiaries could take hours. Trying to do an accounting for a beneficiary would take hours. Keeping up with tax filings would be hundreds of dollars. At a certain point, the bank just didn't see the profit in it. And banks, they care a lot about the profit, unfortunately. A pooled SNT, because they are nonprofit organizations, they are theoretically a little bit more interested in the public service aspect of running this trust. The efficiency is one of the main benefits, but there is that mission-driven statement there. There is a greater purpose to the work that they do. I have here as a pro on the beneficiary's death, the funds remain with the trustee to further their mission. Depending on the agency, that may be a con. Really, though, the pooled trust agencies use whatever is left in the trust, and it's not often a lot for a variety of reasons. With certain organizations, it may go back directly to providing trust services, but there may also be a larger agency. NYSARC, for instance, formed to help individuals with developmental disabilities. So that's kind of their calling. Other agencies have they have a large user base for certain religions, certain groups, certain backgrounds. And so their mission may be different. Your choice of which trust to go with or which pooled trust to go with, take that into consideration what that mission is, because they're the ones who are going to get any benefit from whatever is left over in the trust at the end of the day. Now, I will say it has a drawback, right? It creates an inherent conflict of interest. And so if you're reading the pool trust joinder agreements, which is a fancy way of saying like your application, one thing you'll notice is that several of them will disclose this potential conflict of interest. The less the pool trust spends on the beneficiary, the more money is left for them and their mission at the end of the day. It is a fundamental conflict that the trusts are well aware of. They're going to try to defer when they can to the best interest of the beneficiary, but the conflict exists. It's just part of that uncomfortable bargain we sometimes have to make with organizations to get an overall good result. Now, what I'll say in the cons category here, the beneficiary is just one of many people competing for attention, and this can come at the cost of personal service. Some pooled trusts have individuals who are appointed to everyone. They have a book of business almost. And when you call up as a beneficiary of this trust, you will almost always be speaking to an individual that you have hopefully come to develop some kind of a relationship with, but not every trust is like that. The larger a trust gets, the more inclined they are to become efficient, to make themselves as efficient as possible. And sometimes that means when you send in your light bill, it is paid by a department whose sole purpose is to pay out light bills. When you send in the request to pay for something involving your house, it goes to a specific department whose sole purpose is to make sure that they have a lease on file, that they have some proof of ownership. There are pros and cons to any one of these approaches, but if you're looking for that individual touch, it's something to consider in the initial conversations you have with a pooled trustee. You may not get a single person who will work with you forever, or who will work with you for a reasonable amount of time. I do have a comment here that the beneficiaries may not care about where the funds go to because they're going to be dead when this money is paid out. So they may not care if the money is going to go to the Supplemental Needs Trust and their mission, or to Medicaid and help offset the tax obligations. But for some people, it may be important to them. It's one of those, I guess, for the right beneficiary, that could be a pro. It's a conversation to consider. What can an SNT do? I should preface this by saying an SNT can do almost anything, including all the stuff it can't do. The problem is if it does one of the things, if it breaks one of the rules, like it spends money on housing or food, it can jeopardize that benefit. But most SNTs have some language, some discretion in there that the trustee can violate those rules if they feel it's in the person's best interest. If you have a $10 million supplemental needs trust that you are administering, and you have a beneficiary who says, if I am only allowed to use my SSI check to pay for housing, the place I am living, the place I can afford, is unsafe. It is a dangerous neighborhood. It is dangerous conditions. I do not think I will survive longer here. You as a trustee can absolutely say, to heck with the rules. I don't care if I jeopardize your $818 or $812 of SSI. I am making sure you are in a more expensive place that is safe, that is going to be a better fit for you, for your needs. And I am doing that with my $10 million. And if anyone doesn't like it, they can come at me, and I will show them that I have the discretion to do so. Now, just because you can break the rules doesn't mean you should break the rules. The beneficiary may raise a fight later on and say, well, my trustee, even though I asked my trustee to spend the money on this high-end apartment because I said I would feel safe, they should have known that they should have kept me in the unsafe neighborhood. And so they really went against my best interests in using my money as I asked them to. I wish I could say this doesn't happen, but I have actually seen these lawsuits, and I have seen the beneficiaries win. that that the trustee should not have given me everything I asked them to give me. And because of that, the trustee, who should have known better, ends up at fault. Sometimes the courts, when they hear these cases, they come up with a solution that is as equally unsatisfying as anyone can imagine. They give the money or they award the money to the beneficiary, but they make the trustee stay on as trustee for this new pot of money. So you have a trustee who you've already decided mishandled the money by giving this person everything they wanted. Now you give them a second shot to mishandle the money, and you tell them it's in their best interest not to give this person what the person wants. So the person starts off or continues this relationship with a trust that is a slightly more adversarial, in a slightly more adversarial position than they had been. Now, I say here that the SNTs use stricter rules that say the trustee cannot or will not use the funds in ways that reduce eligibility for certain benefits. Most of the time, we're talking about SSI and Medicaid for those benefits. Theoretically, there's an argument that other benefits could be considered in this, but typically we're talking about SSI and the Medicaid that comes with SSI. Now, we say that the SNTs also direct the trustee to use funds for the sole and exclusive benefit of the beneficiary. And unfortunately, this can create some problems that we'll discuss later on, where the beneficiary has a family or they're living with parents, for instance. And I can say I've been a part of some awful situations where I would like to take some of a $500,000 trust and use that to pay for a beneficiary's phone bill so that the beneficiary can have a phone. Unfortunately, it's a family line, so I am told that I can only pay a certain portion of the beneficiary's responsibility towards that phone, and that the parents who may not have assets of their own have to come up with the rest. I have been in situations where the beneficiary was not receiving SSI, and so we were able to make certain payments for housing, and it has resulted in some hard situations where even though I could pay for housing in those limited circumstances, I couldn't pay for more than a 1/5 or 1/6 share of the housing expenses because I was only responsible for administering a trust on behalf of one individual, the beneficiary. I could not care that by law, I was not allowed to care that this person needed hundreds of dollars to keep the electricity turned back on in the middle of winter. I could only care about their pro rata share of the electricity bill. And it's a really tough situation. Unfortunately, it goes back to that bargain that we have to make sometimes. The SNT, it has to be for the sole and exclusive benefit of the beneficiary. It has its good parts and its bad parts too, right? One of the good parts, as we'll discuss later, it protects these funds from abuse and falling prey to predators. So if someone comes after you, whether it's an unscrupulous lender who gave far too much money to someone who had no way of paying this back, whether it's a friend trying to take advantage of this person and getting free gifts and other assorted benefits, whoever is the trustee gets the benefit of saying, knock it off. There's no way you're getting this money. You should have known not to approve a $40,000 car loan for someone whose income on paper is $800 a month. Why did you think that was a smart loan? I am not paying for that. You made a mistake. You live with it. Now, these conversations are easier to have as the trustee than as the beneficiary. And I will say that when I was the trust administrator or the trustee in any of these cases, I had no problem being a bad guy on behalf of my clients. I love being able to tell an unscrupulous vendor who thought they were taking advantage of my client, sorry, you shouldn't have done that, but there's nothing you can do now. Next time, be a little smarter about this and stop trying to take advantage of people just because you think you can get away with it. Now, the beneficiary can enjoy a higher quality of life than someone with the same legally recognized amount of assets. I have to say I struggled with the wording of this because it creates a system that some may see as unfair. Theoretically, the point of these asset means tested benefits is to make sure that you are impoverished, that you are living at a certain level. And there are social economic factors beyond the scope of any conversation I could have here today about why we think that these are acceptable. That you need to be poor to get help, and that you are not entitled to certain benefits unless you are sufficiently disastrously fiscally unable to care for yourself and placed in such a precarious place. But unfortunately, that is where we're at. There are asset limits, and if you have too much, you can't qualify for certain care, including vital health care, which I know the sea is changing, but we're not there yet. You still need to be poor to get certain kinds of medical care in certain conditions. What an SNT can do is it can make someone that poor on paper while still allowing them to enjoy a certain quality of life. What that means is you can still be SSI level impoverished and enjoy a trip to Disneyland with your family, or have a cable bill that includes high-speed internet and a few premium channels, luxuries that some of us may take for granted. But if you're on SSI, your check will not go that far if you have too many of these luxuries. Is it a fair system? That's beyond me to say, but it's a system that's out there, and the SNT does enable individuals to have that slightly higher quality of life than someone else who is entitled to the same benefits, at least based on asset limits. We promised a little discussion of ABLE accounts here, and it will be a little conversation, but there's such a cool thing to talk about. I really felt remiss if I didn't include them as a possibility here. They're a relatively new creation. They're based on the 529 plan, which you may have heard of in an education context. Put the money aside for kids' savings for education. It can be used for school, tuition, books. It's a great program. Well, this is also the framework for the ABLE account. After coming up with that, there was a thought about what can we do for people with disabilities in a way that encourages autonomy, that makes funds available for housing, which, yeah, I put this as the first bullet point because it's so critical. And it has a number of tax benefits. The distributions can be tax-free. The growth is tax preferred, I think is the exact title. It's just a really great way to make the money grow and to be used for a lifetime of care. The downside, you need to have a disability that the onset of the disability was before 26. And I do not handle Social Security applications, but what I can say is I hear enough complaints from people who are going through the process. It is a difficult thing to prove that you have a disability in some cases. It's difficult to prove when that disability, when the onset date of that disability was. And when we're talking about mental illness, when we're talking about the quote unquote invisible disabilities, it can be very difficult. The applicant for SSI or SSDI, or in this case, the person who wants to use an ABLE account, what is the proof that they have? Is it a level of anxiety that they can demonstrate from high school, from early college, that is somehow distinct from generalized things are rough when you're a kid? It's really hard to prove that. Not everyone had the foresight to go out and get a 504 plan or an IEP and receive special education services for a mental health condition that may not even have been immediately obvious when they were younger than 26. So an ABLE account is unfortunately not for everybody, at least not yet. Maybe there'll be changes later on. Maybe the program will expand. I don't know. I don't have a crystal ball, but I'm not aware of any current movement that will expand these options. It accepts first and third party contributions, but there is a little asterisk here. Whatever is put in there, it's going to be subject to a payback, which again, not everyone wants their money to go to the government when they're done with it. They have other uses. There are some benefits to the structure. I mentioned the autonomy, and I think that's the biggest one here. It can be treated like a bank account. It's not about asking someone, can I use this money? It's about having that agency, that ability to use the money. And in a little while, I'll talk about how I think able accounts and SNTs really go hand in hand. They're not exclusive. It's going to be a conversation about what are those individual conversations that you want to have with that lawyer, that trusted attorney who can give you individualized advice based on your particular settings. But it's going to be a breakdown of what you have, what you're thinking about putting into the supplemental needs trust, what assets you may have available to the able accounts. I can say that I have been at conventions, at seminars, at sessions where attorneys have sworn up and down that it is the trustee's sworn duty to fund an able account to the maximum amount possible as a way of honoring the intention of the testator or the grantor in providing for the individual's life. I have had conversations where the able account it's looked upon as something too new, that it's not been tested yet. There's not a lot of law behind it. There's not a lot of defenses. What happens when the IRS comes to you and they say, I don't think these were approved uses of the funds. Show me your receipts. And the beneficiary says, well, I didn't keep my receipts for however many years. I made some disbursements to myself for whatever reason, and I've moved on with my life. I had a fire, and I've lost most of what I have. And so there's a lot of uncertainty with it. That can be upsetting or frightening to some of the what is the nice way of saying that? To some of the more experienced people who, for whom an able account is still too new to trust. Sometimes as attorneys, we fall into what we know, and we have a certain strategy. We have a certain way of thinking about certain things. And it's like they say, when all you have is a hammer, everything looks like a nail. And if you aren't keeping up with new tools like the able accounts, you may miss out on the opportunity to really advise a client on the benefits of having that. One strategy, for instance, may be using the SNT to fund the able account so that the able account can handle the housing expenses that the SNT cannot, while the SNT handles all the other expenses. But some of these strategies are very creative. And again, there's not a lot of battles that have been fought over these to come to a conclusive statement of law that yes, this is the appropriate and only appropriate way to handle this. How do you create a supplemental needs trust? Now, I'm going to put some caveats here. Number one, call a lawyer if you're considering a supplemental needs trust. Many of the problems that need to get fixed later on happen when someone didn't seek advice in advance of a decision they made. With a trust, for it to be a supplemental needs trust, we talked about how the beneficiary can't just turn it off when they want to. They can't just undo whatever was done. And so it leaves the court with an awful situation of trying to figure out what the grantor's intent was from whatever evidence the grantor left. It can be really, really problematic. Having a conversation with a court that says, my grandmother really, really wanted me to use my money or to use this money for vacations, for high quality of life, to offset my bills, my cable, my internet, things like that, to make sure that I have a working cell phone. Those are the things my grandmother would have wanted me to use this money on. It is really hard when it's just about conversations. There are certain limits on the evidence you can offer of someone who is deceased. And I'll harp on this later on. To the extent that you can make your wishes known when creating a trust, try to give your beneficiary some writing, because they're going to really need that if there is an issue later on down the road. At that time, they will need some kind of solid assurance more than just, my memory of grandma was that she really wanted to take care of me in this particular way. Having said that, and given the preamble, consult a lawyer, anyone can do this. You can put this language into a will. You can say something that kind of sort of invokes a supplemental needs trust, and it will likely be enough to get a court to say, we know what the person meant. The bare basics for executing a will are not that complicated. In fact, they sell will kits online. So I told you I wasn't going to sell my $15.95 trust kit, but if you go online right now, you can probably buy a will kit from someone else and then have 5 blank lines there and say, I want to create a supplemental needs trust for my so-and-so, my son, daughter, grandson, granddaughter, whoever. And it is entirely too possible that that would have more than enough evidence of intent to result in the creation of a supplemental needs trust. Does it mean it's the best idea for you in your particular circumstances? No. If you can get legal advice, it's always worth it. And one thing I'll add on this is that you will not find a lot of pro bono advice when it comes to a testamentary trust involving the creation of a supplemental needs trust. There's a kind of a theory in the pro bono world that if you have the money to be considering how you're going to give your money to someone else, you probably have too much money to be getting pro bono services. So there's a lot of agencies that just won't cover that. It can be costly, hundreds of dollars an hour for an attorney. But if you're thinking of creating a trust of tens of thousands, hundreds of thousands of dollars, consider it an investment. It's well worth it for peace of mind. And I shouldn't be saying this, but the beauty of having a lawyer on the hook for this is that if something does go wrong, you have someone you can chase down for malpractice. You have someone you can say, should have known better and should have advised me. That is not what I wanted to happen. Now, if it's a testamentary trust, unfortunately, you will not be in the position to chase that person down. You will have to hope someone else has some standing on your behalf to do so. But it's better than nothing. It's better than having your family member look at you and say, why did you put my money into an SNT? It was a bad call. Look at all the trouble it's caused. Now I must live with your decision. Joining a pooled trust. Pooled trusts are not joined, they are joined, they are not created. You don't get any say in the terms and conditions of the pooled trust. You have an application. It's going to be called a joinder form for most of these trusts. And if you do not agree with those terms, go elsewhere. You may not be able to find a different pooled trust that has more agreeable terms because unfortunately many of the pooled trusts took their documents from each other and just kept kind of recirculating the same language. What was effective for one, they decided, if it worked for that person, I'm going to use it as well. No sense reinventing the wheel, and there's already case law saying their language is good, or at least salvageable. Now, having said that, a supplemental needs trust created in a will, you have that flexibility, you have that assurance of doing really creative approaches. You can say that you want co-trustees and distributions for certain things, but not other things. With a pooled trust, you are absolutely at the discretion of an agency, its board, the decisions they make. And these decisions can change over time. Once again, you will have no say in any of this. And their decision to change how they administer the trust does not grant you, in most cases, sufficient cause to take the money back and go somewhere else. So ordinarily, this isn't a problem. But certain trusts, if you read their agreement, they may prohibit such expenses as caring for a pet. So if you have a pooled trust with a certain organization, you will have to find some other way of paying for your dog food. You will have to pay for their vet bills, for kennel costs. There is no way you will get that trust to pay for those expenses until and unless enough people complain to that trust, and that trust their board, whoever is involved in the decision-making process at that trust decide, you know what, maybe people with disabilities deserve animals as well. Or maybe they need to rethink what it means to have a quote unquote pet. Harkening back to a NAMI perspective here, service animals, support animals, without proper education, they may be considered a quote unquote pet by one of these trusts. So it can lead to that really heartbreaking situation where, of the limited assets and resources you have available to yourself, because remember, you've impoverished yourself to obtain some sort of benefit. That's why we have the trust in place in most cases. You now have to decide what's more important, my rent or my dog's medication, the surgery that my cat needs. It's a heartbreaker. Some of the stuff is a little bit less of a heartbreaker. Many trusts have a prohibition that they will not be able to buy fireworks. That may not be a deal breaker for many of us. We might just say that's a luxury, and I'm sorry that you will never be able to buy fireworks, but I'd much rather you have the services and benefits of the pooled trust, of SSI, of whatever other, of Medicaid. Now, I say here, theoretically, this can be done independently, but some strongly encourage using an agency or individual to complete the submission. I had to use so many wiggle words here because as a practical matter, I'm aware of pooled trusts that have made it nearly impossible to accept documentation unless the applicant says, my relative, son, daughter, my attorney, my advocate from this agency or this other agency will be submitting this documentation on my behalf. And what their stated language is just, who's that contact that you want us to tell your information to? Hey, who do you know could be submitting this on your behalf? And you could argue, I will be submitting on my behalf. I do not need to share my information with anyone. My disability is my own business. But from a practical standpoint, there may be some difficulties with some supplemental needs trusts. This is a conversation or a consideration to have when you're going through that application process. Are you going to make me work through an attorney? Are you going to make me go through it with an advocate, with an organization that will submit this on my behalf? Or am I capable of doing it by myself? The main thing that the pooled trust is looking for is to shield themselves from liability. They want to make sure that the individual who is submitting the paperwork does not get to back out at the end and say, I did not know that I had to comply with certain requirements to get Medicaid to honor my trust. I did not know that my funds, my deposits would be irrevocable. I thought I could take those back. If only someone had been there and could tell me otherwise. The trust, by making sure you have that individual in place, they get the plausible deniability. They get to say, I don't know what you knew or did not know. All I know is such and such an agency submitted this on your behalf. Your daughter signed off on this. They must know what's going on here. If you didn't want them to submit this, then you shouldn't have given it to them to do. It's a very cynical approach, I know. It's hopefully something that never comes up in any of our lifetimes, but sometimes it's better to be a cynic than to be a victim. Choosing a trustee is a really difficult conversation. Oh, checking on time here. We have been here forever, and I understand that you guys all have a ton of stuff. So I'm going to skip ahead. I'm going to skip through the choosing a trustee section, and we're going to talk about it lightly. Basically, choosing a trustee is a really complicated conversation to have. There's professional trustees. They are banks, they are attorneys, they are trust companies. Again, they want, for the most part, a high dollar amount, which may or may not be in the cards, depending on your personal life and whoever else you may be giving money to, and whatever ways you want to enjoy the funds while you're alive. Then there are the friends, the families, the siblings. They can be a great choice as well. With a professional, you have that distance that can come in handy. You're not fueling personal discord amongst siblings. You are not putting a brother in the awkward situation of having to tell his sister, no, you can't have a car because I don't think it's in your best interest to have a vehicle. You get to save yourself all of that potential family drama that you may not be there to help mediate. With a professional, it's on them. Leave it to them to decide why they did what they did or make the decisions they did. The downside, you're a robot. You are one of many people that they are dealing with. Whatever personal nuances you may have, whatever full and realized life you may have lived, gets distilled down to a series of notes that they enter into a computer, and that hopefully the next person who gets your account will look at and say, okay, now I think I know what this person is like or what they are about. It reduces people in a way that's not always great. So again, friends, relatives, it can be a burden. It can be a lot to ask for. There's tax consequences that they need to be aware of. There are distribution consequences that they need to consider. It can be really, it can be a lot to ask for. Trustees can, however, get professional assistance. They can hire lawyers. They can hire investment bankers. They can hire individuals who can help them make decisions. The money for those people does not come out of the trustee. It comes out of the trust. So that is a good thing. In some cases, it's a bad thing. If I knew that I would have to pay for a private attorney to make decisions about how I would be taking care of someone else, I would probably be a little bit more reluctant to take on that responsibility. But knowing that that money comes out of the trustee and that the grantor or the donor has considered those issues when they made the initial decision, they knew that at some point I may need an attorney. They knew that at some point I may need professional assistance. I can rest easy. I can know that this is a good use of funds. SNT rules: carry out the purpose of the trust, act in the beneficiary's sole interest, be ready to explain their actions, understand their duty to invest. We sort of touched on the first couple of these. That duty to invest is not a requirement that you throw everything into the risky stocks. It's not a requirement that a trustee only invests in Apple stocks and hope that it takes off and continues taking off. It's a duty to be smart. Even a savvy banker with millions and millions of dollars in their portfolio may keep a certain percentage of the account in cash so that it's liquid, so that it can be used. They may have a certain percentage in safe investments like CDs. They may have a certain percentage in really aggressive investments because they know it's a trust for the benefit of a 20-year-old. And if the return on investment doesn't beat inflation, it's not just not growing, it's shrinking. Your $100,000 today growing at 0% is not going to be worth that much 10 years from now, 20 years from now. That's the present value of money at work. I talk here about how the trustee can seek help from professionals, and I said that it's a good thing or a bad thing. Many of us have probably tangentially heard about the Britney Spears conservatorship issues, where her guardian, and I know it's not an exact translation here, but her guardians had used money for things like bodyguards and had extensive amounts of money going towards professionals. And all of the lawyers that her guardians are using against her and to stifle her own expression of autonomy comes out of her money. So she needs to ask for permission to buy her own legal assistance, to challenge the people who are also using her money to defend the decisions they made that she's accusing them of making badly. And a trust can put you in that same position. I hesitate to give the quote, but it was a quote that was given and it was a horrible thing to say. But one time when I was working, I actually had one of my supervisors deny a request for assistance for an individual based on the fact that I'm not paying someone to tell me I'm doing a bad job. And that is unfortunately a decision that a trustee can sometimes make. The beneficiary of a trust has to know they can try to find the proper venue to raise this in. They can raise the issue by themselves just by going to court and saying, "Dear court, you are the court I believe has jurisdiction over this trust. Help me out here. In plain language, I have been the victim of a wrong, and I need you to help make it right. It doesn't need to be fancy. A petition will always help, but it's really hard to get an attorney to sign on when you're telling them, I'm paying you on the promise that at some point in the future, if we're successful, you might be able to get my trustee to pay you. It's not always a winning proposition. It's a very hard sell. And it goes back to that. Sometimes the trustee can be a bit of a bully. The trustee can have that conversation with the attorney and say, yes, I do have $500,000 here. That beneficiary does want some of it to use to pay your services. I will not give you anything. You will get absolutely nothing from this trust. And you are hoping that that beneficiary will somehow scrape together $250 an hour for your services as you fight me. And the more you fight me, the more I'm going to pay my other attorney to challenge you. And at the end of the day, there will be nothing left in this trust. And that will be the end of this. This is why it's really important to figure out who that trustee is. Do you, as a donor or as a grantor, feel comfortable with this person? Have you made it clear what you want the funds to be used for? Some of the cants here: don't commingle funds, don't self-deal. I could give you all kinds of fun hypotheticals here about self-dealing. Like, is it self-dealing if you have, if you as the trustee have a house cleaning company on the side here, and you would like to pay yourself money to perform housekeeping services for the beneficiary, who may or may not even want those services? Maybe, again, we're getting into some fact-specific things here. It's always great to go over this with an individual representative, an attorney, an accountant, someone who can look at your personal situation and say, this is fuzzy, this is definitely over the line, or no, they're well within their rights to do this. I mentioned the word accounting here. This is something that a beneficiary of a trust has as it's always something they can ask for. The courts are never going to say no to an accounting. They may say you need time for an accounting, but they won't say no to it. What an accounting is, it's like a statement from the trust. The trustee has to say, here's what I got, here's what I spent it on, here's where the investments grew, here's where they shrunk, but this is what I did. Trustees are encouraged to volunteer accountings because it starts that ticking clock of when they have to receive any objections. It's kind of like at a wedding when someone says, if you have any objections, speak now or forever hold your peace. The filing of an accounting by the trustee is setting that ticking time bomb. If you thought I was doing something wrong, the time to raise that is not 20 years in the future when you have decided that I really shouldn't have bought you that Porsche at the age of 19. It was when you were 19 and I gave you that Porsche and I gave you a statement saying I bought you a Porsche. That's when you should have told me I did the wrong thing. Don't rose hit my world. Don't go back on hindsight. No, your time has long since passed. I have a mention here that SNTs cannot be a passive part of the relationship. What that means, or the trustee cannot be a passive part of the relationship. The courts have increasingly found a rule that if you are managing a trust for someone, it is your responsibility to find out what that beneficiary needs. Typically, this gets used against banks because the banks are all too happy to have $1 million sitting there and to not bother reaching out to you. But if the beneficiary is incapacitated, if the beneficiary is, for whatever reason, unable to make clear their desires, how on earth is that money ever going to get used if the trustee doesn't get up and actually earn their money? If they don't do something to earn that fee, go out there, figure out what the beneficiary needs. If the beneficiary can't communicate, is there a caregiver? Is there someone there that you can talk to? You don't get rich off this. You have to do the work. Preventing abuse and encouraging autonomy. The trustee is protector. This is one rule that I think many of us who are trying to care for someone else, this is the ideal relationship. That trustee is going to protect our loved one from the predatory lender, from that awful girlfriend, boyfriend, whoever that wants to take care of or wants to take advantage of them, that wants to use them as a free ride. That's who we want to protect. It's a very optimistic goal. The trustee can also sometimes protect an individual from their own worst behaviors. That's that hypothetical I gave you earlier. That's not a hypothetical where the trustee spends way too much money on the beneficiary, and the beneficiary is like, you know me, you shouldn't have spent that money. You should have realized I was not going to do anything positive with that. One example I had from a lived experience, I had a beneficiary multiple times ask me for hundreds of dollars of jewelry. And I kept giving it to him because who doesn't deserve jewelry? Just because you have a disability doesn't mean that this very large pot of money couldn't be used on your benefit. Unfortunately, at one point, the beneficiary did let the myth fall that they were in fact selling the jewelry. It was easier to get me to buy expensive jewelry and then sell it at a fraction of the price than to get me to give them cash for things that I could not give them cash for. And so I was unable to really exercise my trustee duty there. I wasn't able to save them from themselves. They were making horrible decisions that they really wanted to. But sometimes you get to make horrible decisions. Just because you have a disability doesn't mean you don't get to make bad decisions. Sometimes people without disabilities make just as bad, if not worse, decisions. We don't get to blame it on a disability. Trust can serve as a less restrictive alternative to guardianship. One of the caveats here is that sometimes being taken advantage of can be used against a beneficiary, against an individual with a disability in an APS proceeding or in a guardianship proceeding. An individual petitioning for guardianship will say, if my loved one was able to take care of themselves, they wouldn't have been victimized. And because they were victimized, someone else needs to come in and become their guardian. Someone else needs to make decisions on their behalf. So a trust can be a less restrictive alternative. Sometimes you need to protect the beneficiary from the trustee. This I've seen most often in family dynamic issues where a sibling who happens to be the remainderment of a trust is all too keen to use trust funds to fix up that house that they're going to get as soon as their sibling dies, but they're not so keen to buy the things the sibling needs right now, or things that have no long-term benefit for anyone. The cable bill. You can get by with basic cable. You don't need anything fancy. What's the cheapest cell phone plan I can get you on? That's what I should use the money on. But I do think mom's house needs a new sunroof, so let me put that in there. And yes, my kids are going to be living in that sunroom in a couple of years' time. So trustees generally get to use trust assets to defend themselves against accusations and can deny the beneficiary funds to challenge them. I have to say that it's one of the most frustrating things about the trust world. So I want to make sure that I really hammer that home. Practical steps with a trust that you create. That's not the pooled trust. That's the trust you create or the individual creates. Co-trustees. Sometimes people are less likely to behave badly when they have someone looking over their shoulder. And the power to remove a trustee isn't the same as being able to revoke a trust altogether. How this can look, you can say that my beneficiary, if they're unhappy with the trustee, can, with consultation with someone else, with a quote unquote trust protector, can remove the trustee, can ask for a new trustee. It's one way of keeping that person on their toes. Not having an ability to remove a bad trustee can lead, or a trustee who's given up. Sometimes you just give up, and it's not great. It's not what we hope for, but you've been taxed, you've been exhausted, and this job just isn't for you any longer. Having an ability to replace that person with someone else is something even the trustee may value. Having that ability to say, if you don't like what I'm doing, you have the autonomy, you have the ability to make this decision. Go ahead, find someone else. I will support you in that. Encouraging autonomy, be clear about the intent. What did you want the money to be used for? Can you leave this in writing in some way? Can you write a letter? Can you have a conversation on tape? Something that can be admitted into court to have someone say, a third party say, I objectively know what the person's intent was. I mentioned being comfortable with bad decisions. That goes down to you can't always punish someone. Sometimes they're going to do something absolutely irresponsible and immature with money. And sometimes a trust is overkill. Just because someone was bad with money in their 20s doesn't necessarily mean they're going to be bad with money in their 30s or 40s, or that they haven't grown by the time the trust comes into fruition. It's one thing to do is, I say here, presume competence and plan for capacity. You can absolutely put language in the will that says, if when I pass, so and so, my son, daughter, whoever, is incapacitated or is receiving disability benefits, then I want you to put this money into a trust. If not, it's theirs. Let them spend it. I don't care. I'm gone. Let them have a good time. But it's really important to make sure that you plan for that incapacity. The last bullet point here I have is to consider the privacy considerations. This is something that I used to recommend when people were writing their wills, and they would be tempted to have a nice little paragraph explaining why they were not giving anything to someone or why they were preferring someone else. They wanted to spell it all out in that will, which is going to be given, a copy of that will, to each and every person named in that will. And so maybe the thing you don't want to do is to set forth the multiple ways in which you feel your son or daughter or loved one has an undiagnosed mental illness, and all of the evidence you have for your suspicions in this document that's going to get distributed to all of their siblings, to everyone that may be around them. Maybe you want to keep this a little bit more private. Maybe you want to use language that is considerate of the possibility. You can say things like, if it is necessary, or if, going back to that language I used earlier, if any individual receiving a distribution under this happens to have a disability, that's when I need you to make a supplemental needs trust. And here's what I want that supplemental needs trust to look like. There's planning around this that can be done. You don't necessarily need to disclose everything, especially if the individual themselves disagrees with your assessment that they may possibly have an undiagnosed disability. It's a really frustrating thing. I think I'm almost at the end, and I know I've kept everyone. So I'm going to turn it over to Ms. McGee, and we can have questions if there's any time. I went over. I'm sorry, everyone.
That was really very comprehensive, and I really appreciate it. You covered so many things that you answered almost all of my questions that I had prior to this. So I'm going to go ahead and encourage people to put their questions in the chat. And we do have a few. Let's see. Let me open this up. We had a few. So one question was, what can someone do if their parent passes away and they don't have any money for funeral expenses, for final arrangements, and they only live on disability and have no savings? Or what can a family do about that?
That is a tough call. There is a small death benefit from Social Security. I believe it is really small. I wish I had something better to say and something more hopeful. I know there are minimal requirements that you have to be buried somewhere. It's not going to be a luxurious grave site. It's not going to be a fancy stone, but you can get a space. It's really tough. What I can also say is there are certain requirements, and why'd you have to start with a heartbreaker here?
Oh, I'm sorry.
No, that's tough. That's tough.
One thing that we have done, well, we did this when our children were young, was to have a small life insurance policy just for that reason. So the premium is very small. Of course, it would be more expensive for someone older, but the premium was quite doable, and it would be just enough money, say a $10,000 life insurance policy, that would allow for burial expenses. To cover burial expenses in the event that they were to pass away. That's one way that we've managed that in our family.
One thing I can say is that I have personally encouraged my family to opt out of, at least with regards to me and my final disposition, opt out of the funeral industrial complex, and don't get me a fancy casket. Don't pay for expensive tchotchkes. You do not need $140 a crystal made with my calcified ashes. Don't do that. Check your local regulations, but you can be brought home in a very modest container. It does not need to be fancy. It can be a wooden box. It can be something very bespoke and very, very tasteful and also affordable. I would much rather my family use the funds that we do have on things to honor my memory than on things to hold my compost.
Thank you. So let's see. People wondered if you could please show the last slide there with the number with your information on it. That would be great.
Oh, sure. All right. Back to the share screen.
And we have another question. Oh, where did it go? I lost it. Let's see. My cursor is stuck.
All right, there's the contact information for Disability Rights New York. And I believe we can make this available through all of your channels, and okay. I'm sure you can make sure that it's available to whoever wants it.
Okay, great. So for people who have rarely needed to deal with lawyers, what is the best way to find a good lawyer who can give advice and help create or join a trust?
Oh, in general, you can call up the New York State Bar Association's legal referral hotline, and they will find someone in your neighborhood. For an initial consultation, there's a $25 fee. I think it's $25. That's the initial consultation fee. It's usually enough to give the lawyer a good sense of how complicated your wishes are and how to make them a reality. Having said that, though, if you want a more tailored approach, you may want to contact the Elder Law Bar, the National Association of Elder Law Attorneys. You don't get that $25 initial consultation, but depending on the lawyer, there may also be a free consultation. There may be a low-cost consultation. It's a conversation you can have, or you can approach it as an investment. Typically, if they're in the Elder Law Association, we're not talking about a fly-by-night attorney that just thought I can make, a couple of $100 an hour fleecing people at their most vulnerable time. It's individuals that have put some thought into the trajectory of their career, their interest, and they are cultivating a practice in a very niche area. So that's my thing. That's not to besmirch the fine folks who are available from the New York State Bar Association's general consultation line. And that's really the best option I would give. You can Google, you can search online for elder law attorneys near me, but you never know who you're going to get. You could get an attorney that sees it as a quick way to supplement an income stream, and they have a will and a trust that they will put up your name onto, and they will print it out, have you come in and sign for a flat rate of $1,000, but sometimes you get what you pay for. And it's sometimes worth having a conversation about what your planning wishes are. And do you have any experience with Medicaid planning? Do you have any experience with supplemental needs trusts? Having those kind of conversations can hopefully give you a little bit more comfort as to whether or not this is something that the attorney actually practices in regularly, or it's something that they just put up on their website, hoping to get a few clicks and the occasional extra case.
Thank you. This is a question I actually had written down, so I'm really glad someone asked it. You said in a third-party trust that a beneficiary cannot revoke the trust. What if the beneficiary gives up their benefits? What happens to the rules about interfering with benefits?
Oh, you're calling me out on a technicality because I put that in there. They can't revoke the trust, but I was using revoking in a loose sense in terms of they can't just terminate it. They can't just say it's not there. And I was using it in a technical sense because it wasn't theirs to revoke. I was using revoke to mean like to get back which was once yours. And so unfortunately, in a third-party trust, the beneficiary can't really do much about the wishes of the grantor. I, as the grantor, get a lot of discretion as to how I want my money to be used. And so if I say it's going to be held as a supplemental needs trust, then by golly, it's a supplemental needs trust. And regardless of whether or not you as the beneficiary agree with that or not, questions about whether or not the person is actually eligible for a supplemental needs trust is a different issue. But I also, as the grantor, could create a trust that has all of the earmarks of a supplemental needs trust. And there's no language that says it's an SNT. There's not even a need. It's just these are the rules that I decided to put on the money. That I did not ever want you to use the funds for housing or food. And I could just be doing that out of some misguided sense of what I would like you to do with your life. And I want you to support yourself, but know that I'm here for a good time afterwards. Or I could be doing it because I was trying to create an SNT and couldn't come up with the words. Mm-hmm. It's really frustrating. Now, when it comes down to whether or not the trust can be terminated, that is, you'll likely have to go to court for that. It will likely require the consent of everyone involved with the trust, which means the consent of the beneficiary, the consent of the trustee, and quite possibly the consent of the remainderman. You're not going to have any problem with getting the remainderman to agree to get their share of whatever this money is early. They're almost entirely happy with saying, this trust can be done with today and I want my share. They may be less happy though if the distribution is going to go first to the beneficiary. So it would have to involve some really complicated thought going into, I want the trust to be held as a supplemental needs trust for my son, my daughter, whoever, for as long as they're receiving benefits. If they are not receiving benefits, and for whatever reason we decide it's not a supplemental needs trust anymore, I'm giving my beneficiary the option of somehow getting a disbursement from this. And even then, this is language I would not test, okay? Mm-hmm. I will say, this is me spitballing off the top of my head. I wouldn't test this language, but theoretically there could be some language about I'm giving them the ability to terminate the trust if these conditions are all in place and there's no need for it and everyone agrees there's no need for it. But then whoever may have received the benefits of that money being held in trust upon the death of the beneficiary, they may say, I'm not comfortable with so-and-so having that money outright. I think that money still needs to be in a trust because I could get some of it if it's still there when that person dies.
So there's some complications that are coming to mind for me, and some differences between some people with what would be considered a disability aren't necessarily impaired in their thought processes. So some people who might have a disability would be a mental health disability that they might have, and these are like real examples, some suspicion about the where the money came from or the system with which the money is sitting in or is being managed. So they might reject it outright. And this is just something that, when this person asked this question, that's where my mind went. If that person rejects it, what is the process of who gets the money and how do they determine that? And then if they were to determine at a later date that they're well and they didn't want to do that, and somebody should have realized that, that just offers a lot more complication to that. That's just I don't mean to complicate your question answering anymore.
That's fine. Can a beneficiary renounce their interest in a trust? Yes. Can they later regret it? Yes. Can they go back and say, I regretted that decision and I want to go back? Probably not. Just spitballing, I think you're going to run into an equity issue where the court's going to find it unfair to say, I presumed that this person had capacity when they rejected the money. I'm now asked to presume that they were incapacitated and that all the people who are now benefited from this are going to be harmed by this presumption. I suspect that most courts are going to presume the capacity of the individual. And my organization, for instance, we would presume that capacity as well, that they were just making a self-destructive decision. They didn't trust the money. They said, I don't want it. And they renounced their share. That's their decision to make. As foolish as it may be, and as short-sighted as it may be, that is their decision to make. And they may regret it later on, but that regret is a luxury we all get, disability or no disability.
Okay, thank you. What would you recommend for a person whose disability prohibits them from acting as on their own as a beneficiary?
I may need some more advice on this question, but I can give some examples. So I've worked with clients who, due to a mental illness, present themselves as very destructive in terms of relationships. They make it very hard to talk to engage in phone conversations. I have had staff members who have been threatened with assaults and physical harm from clients, and it is incredibly frustrating because I have a responsibility to carry out my duties as a trustee, but I also have sometimes a relationship with staff members where I have to take care of them. I can't allow them to be endangered. In these situations, trustees have used trust money to buy case management services. So that's an option in some cases, which is expensive, and it can use up a trust really much quicker than it needs to be. And sometimes when it's a temporary fit, it's not what fixes the problem. So when I say it's a temporary fit, what I mean is it may seem like it solves the problem. It may seem like it's the perfect way to approach this. But then what you have is a client who 6 months down the road, there's been a medication adjustment. They were in a bad place, in an unhealthy mindset, whatever. Right now, they're much more compliant with their medication regime. They're much more willing and open to engage in discussions. Now, all of a sudden, you're stuck with, that's fine, but I've got this system in place where you have to send a request to a case manager who's going to charge your account hundreds of dollars, and they're going to pass it on to me, and I'm going to write the check. And I don't want to take the service away. I don't want to muddy the waters and get back involved in a direct person-on-person relationship with you. But so now all of a sudden that tire doesn't fit anymore, does it? Now all of a sudden, it's almost like you as the trustee are wasting this person's money because you came up with a solution that's just, it's not quite what you need anymore. It can be problematic, but there are solutions. And in some cases, the solution is the trustee just stops communicating with the beneficiary for a while. I have seen relationships where a trustee would love to spend millions of dollars on behalf of an individual, but that individual just will not ask them for anything. The individual once said, I need housing. This is the only thing I need from you. Pay for my housing. The trust said, I would do anything but that. It's like the Meatloaf song. And unfortunately, this was enough to sour the relationship. And in an exercise of what I determined to be self-destruction, the client would rather be homeless with nothing than, or almost nothing, than to avail themselves of services that could get them a home and have a trustee who would spend millions of dollars on them, who would love to give them cable and phone and all of this stuff, but can't. And so to spite this bank that he does not like dealing with, he's allowing them to keep the money as it grows, and they still get their fees, and it gets larger and larger, and they get more and more money. This is his act of rebellion, is to ultimately allow this bank to get richer and richer.
It's complicated. Thank you. What sort of a question I had is, what sort of risk is there in pooled SNTs? So they invest the money, correct? And is there a guarantee of at least the investment that your loved one made on your behalf? Is there a risk of loss there? Let's say it was an unscrupulous organization that ended up having this pooled SNT. What is the risk?
That is a great question. What I can say is that the pool trust world is very conservative, small c, not political. They are more likely to invest as cautiously as possible with very minimal return on investment, rather than risk large swings in the stock market. This is an act of frustration for individuals who are younger and could really benefit from a more aggressive stand, a more fiscally daring investment approach. But in the long run, the pool trust takes the opinion, or most pool trusts, I won't speak for all of them, I can't speak for most of them, but they take the opinion that we have to look out for all of the millions upon millions of dollars in our care. We can't act aggressive on certain things and then have that amount be covered by the people who have 6 months left and then they're not going to be with us much longer. We need to look out for the overall health of but they're all going to have a giant asterisk saying, we do not guarantee a return on investment. This isn't an investment product. You are at risk of loss. What I can say though is that risk of loss is very minimal. It's like the world's broadest index fund. They go for diversity over all else. You're more likely to not keep up with inflation, and the best part about most pool trusts is that because you're dealing with such small levels of investment, it may be okay. You're not necessarily thinking about how do you make that $1 million appreciate over time to keep pace with inflation, to keep throwing off enough money and income to support my beneficiary. You're talking about a few $1,000s that could easily be exhausted in a nice vacation. A couple of years of buying clothes for a friend, maybe a car if at one point they need a car.
Okay. I wanted to also mention briefly in the comments, someone mentioned that Green Spring Cemetery they think that is a reasonable cost. I know that's a natural burial cemetery also. And someone else mentioned a possibility of a GoFundMe if people wanted to crowdfund some expense for final arrangements. I have one more question. So I just want to encourage people, if you have any further questions, please put them in the chat as we move toward finishing up this evening, and we'll get to them. I know that some people who are receiving some disability benefits also are able to maintain some employment at some level. So if they are, and also receiving benefits, and they're meeting the limitations with their employment that disability puts on them financially. What happens if they end up being a beneficiary of an active trust due to the loss of their loved one? With regard to that employment situation, if that's something that's bringing value to their life, and that complicates things.
The good thing about most SNT trustees is that they are not that invested in the lives of the beneficiaries enough to care much about the individual and how productive they are working, etc. They're a little bit distant. It's a transactional relationship, and so they may not even know that you have begun work and that you are having a full and productive life outside of that handful of times a year that you interact with them. What will be more concerning and more dangerous is if at some point the Social Security Administration says, congratulations, you've been working under one of our plans, the PASS plan, something like that, ticket to work, and we've successfully determined that you can engage in SGA, substantial gainful activities, and you are absolutely capable of supporting yourself via work. We are turning off your benefits. That's when your trustee is more likely to get involved, because now it's a question of, well, if they're not a person with a disability for Social Security purposes, are they a person with a disability for our trust purposes? So it's an interesting question, but overall, your trustee, if they have a relationship close enough with you that they know about your work history, things like that, they, at least from the trustees I've encountered, would be more than happy to help you in whatever way you've got going on. Tell them you need a car to get back and forth to work. They'd love to make that happen. That is a great use of the trust funds that no court on earth is ever going to fault them for. You provided something of substance and meaning using funds dedicated to that purpose. The Special Needs Trust or the Supplemental Needs Trust does not have any desire to keep you from work or to keep you impoverished. It's just that there is a pool of money set aside that, by setting it aside, has functionally impoverished you. But if you want to work yourself out of poverty, go right ahead. They are not going to stop you. They will do what they can to help you if you need it. They may even assist with education, with training. I had one client, he wanted to go to welding school, and I loved him for it. I wanted to pay for his tuition. And then he decided he didn't. He just wanted to blow it on a sports car. And that was a horrible decision that I had said yes to, and I regret it to this day, but it's okay.
Okay, would you stop the screen share?
Oh, yes.
David, I think we've got the information that we need. And I am not seeing any more questions in the chat. So I really thank you for this. I think your presentation was really thorough, and I really appreciate it, because it inspired thinking, and then you'd answer a question that I had in my mind when I heard you speaking. So this is actually the first time that I've felt really informed and able to direct people to a resource when they ask these questions in a support group. Having this recording on our YouTube channel will be really great to have and make that easier. So it's just such an important topic, and we do, people stress about it and worry about it, and it's challenging for families. So do you have any final thoughts that you want to share before we finish this evening?
No, as the slides prove, I've given all my thoughts out. I'm not shy with any of them. If I had any thoughts, I would have given them away already. I'm just so glad that I was able to stay here and talk with everyone tonight. It was a fun opportunity. I'm always happy to share my knowledge. I hope we all got something out of it. I know I got something. Those questions were really thought-provoking. And I just love the opportunity to be able to put this together and speak.
Thank you. And I want to thank everybody for attending because you really help us out with your questions, getting as much information out as possible. The recording will be available probably early next week. And that can be found just by Googling NAMI Finger Lakes YouTube. And let's see, you can subscribe to us there. So whenever we have a new video up, you'll get an alert about that. And you can also find us at NAMI Finger Lakes on Facebook and Instagram and at namifingerlakes.org. So with that, I will say good evening, everybody, and be safe and be well. And thank you so much again, David.
You're welcome. Have a nice night, everyone.
Too.